Uh-huh.
Hey everybody, it's Jeremy Robert here with the agency in Pasadena, and today I'm chatting with Tony Barilari and from Barilari and Williams. And Tony is a estate planning attorney, probate attorney. Do you do litigation as well, or what are all your different things that you guys do?
We do. So in a nutshell, our firm focuses on estate planning, probate administration, trust administration, and then litigation surrounding probate and trust. So will contests and trust contests and various trustee litigation, et cetera.
Okay. It sounds like a lot, but I'm sure it's all kind of within the same little realm of expertise, right?
It is. It is. Yeah. Essentially, everything having to do with trust and estates is what our firm focuses on.
Okay. Okay. Perfect. And so jumping right in, I have a few questions for you that I think people would want to know about. I'm a certified probate real estate professional, so I run into some of these things, and I work with you guys on some stuff and some other trust attorneys. But people ask me, and I figured it's best to go straight to the source and ask you, how do you, probate is a thing that you don't want, right?
That's absolutely correct.
Okay.
Probate takes a long time.
Mm-hmm.
Generally, the minimum length of a probate administration in the courts is 18 months, and it's very common for them to extend out to 24 months. The courts are backed up, and the system moves slowly and is actually designed to move slowly.
Yikes. Yeah. Okay. So the big question is, how do you avoid all of that mess, all of that nonsense?
Well, fortunately, the solution to avoiding probate is really simple. You need to have an attorney that focuses on estate planning, prepare an estate plan for you. And there are lots of devices in the large realm of estate planning that can be used in order to help your estate avoid probate, which is much cheaper than probate, much faster than probate. It gets the money to your loved ones a lot quicker and with a lot less hassle.
Okay. And the simple version of that is to do a trust.
Correct. For most clients, for most people, putting a trust together is key. There are a myriad of reasons for that, not the least of which is the transfer of real property from one generation to the next is much more easily facilitated by a trust, and having a trust in place that holds that property bears much less risk than using other schemes like the transfer on death deed, and joint tenancy deeds, and et cetera, that are also available in California.
Yeah, because for pretty much everything can be litigated, I'm assuming.
Everything can be litigated, but there are other pitfalls that have to do with probate risk, actually, that are inherent in having a transfer on death deed or a joint tenancy deed as your means of transferring property from one person to another. And there are also property tax reassessment implications to that as well.
Gotcha. So deep and lots of information, I'm sure, in all that. So if you're watching this and you need a much deeper dive into that, call Tony. He will kind of go in it with you. So kind of going into back to the probate thing, there's an executor, right? That somebody that kind of goes through the process and handles all that. How do you become that person?
So there are a couple of ways that one can become the executor, or the term that we use most often is personal representative. So in a probate, you can have an executor who's somebody who's named under a will to administer the estate, or executrix. The other term is administrator, and probates where there's not a will. And the term personal representative actually encompasses all of those. And the way to do that is, if there's a will, you lodge that will with the court and you submit a petition for probate. And if you're the named executor in the will, then you becoming the executor is pretty much as simple as that. In cases where there's no named executor, or if all named executors are predeceased or otherwise unavailable to administer the estate, then the state has a statutory scheme in place for determining who has the priority to administer that estate. So if two different people are vying to become the personal representative of an estate, in the absence of a provision in a will determining who that should be, the court has this statutory scheme. And basically, the order of priority is a surviving spouse or domestic partner comes first.
Okay.
After that, it's children and then grandchildren, or other issues. So further down the line, great grandchildren, etc.
Gotcha.
Then after that are parents, and then siblings, and the list goes on and on. It's pretty exhaustive, actually, what the state has come up with for who has priority to administer an estate.
Gotcha. Yeah, covering all bases. I feel like California's good at digging deep in the legal aspect of all that stuff. So okay, cool. So obviously, we talked briefly that probate can be expensive, just real briefly touch on some of that, because I'm sure, as people are considering, hey, I'm going to put a trust together, or I'm going to, we don't really have much, like, what are some of the costs and what are some of the major costs of like having to go through probate?
Sure. Well, we'll start with the non-attorney's fees, which themselves are not insubstantial. So between filing fees, and there's a filing fee at the beginning and one at the end of every probate, a substantial filing fee. There's publication that needs to be done with a newspaper. And also, oftentimes, the estate will require that the personal representative get a bond. And all of those fees, I would say, average out to about $3,000 per probate. And that is regardless of the size of the estate. So that is coming off the top right away.
Gotcha.
The attorney's fees tend to be the highest single expense of administering the estate, depending on whether there's real property or not. But the attorney's fees are pretty substantial as well. And they're on a sort of reverse graduated statutory fee scheme is what they're based on. Important to note on that is that the attorney's fees and the ordinary attorney's fees they're based on the gross value of the estate. So let's say a very, very simple case, the estate owns a home and the home is worth $1 million, and there's a loan on the home, a mortgage, and that mortgage is a $700,000 mortgage.
Okay.
Well, the statutory scheme sets it up so that the attorney's fees are based on the gross value of the estate, which means the attorney's fees are based on that $1 million value, not on the $300,000 equity that is there.
Wow.
So they can cut in pretty substantially to what you are ultimately able to pass on to your beneficiaries and your heirs.
Yeah, that's interesting. I would have assumed that it was just at 300, but that's interesting. Yeah, that can be substantial.
It can be. And so the way that fee scheme works is it starts out at 4% of the first 100,000 of gross value. The next 100,000 is 3%, and the next 800,000 after that is at 2%. And then anything over that, up to the next 9 million, is at 1%. Wow. Well, it's pretty rare to have an estate need to go through probate when it's larger than that. There are cases where it happens, in, I believe it's Minnesota, where Prince passed away, where he resided. His estate was worth tens of millions of dollars. I'm not sure of the exact value. And that estate is going through probate. And in fact, I believe there are still proceedings regarding that estate years later.
Yeah.
The larger the estate, the more complex the administration is. And that's one of the reasons why we have this reverse graduated fee scheme in place.
Yeah, interesting. Very interesting. Yeah, I mean, that's, and I thought I knew a little bit about probate. There was a piece in there that I didn't even know about the gross of the the value. So that's
Sure.
interesting.
And that doesn't spell the end of the fees either. So
Yeah.
that fee scheme that the state has in place here in California is for what are deemed ordinary probate services. So this is all of the what you might call run-of-the-mill estate administration tasks that an attorney performs. And there are a lot of them. They're quite substantial. The fee scheme, while it seems very high, is actually pretty justified given the amount of work that we put in. But there are other fees called extraordinary probate fees, where you're going to be paying your attorney by the hour to complete certain other tasks. And those include things like defending a will contest, or having a personal representative removed, or defending the removal of a personal administrator in favor of someone else. And there's quite a few other types of services that an attorney can provide that are deemed to be these extraordinary services. So those can be on top of the statutory fees for ordinary services and on top of the filing fees and et cetera that I mentioned earlier.
To include like litigation fees, say one family member is suing another family member, it's probably above that as well. Is that considered the special, or is that something different? Or
if it has to do with the estate, then yeah, those are going to be what are deemed extraordinary fees. So those will be in addition to the statutory fee scheme. And as you can imagine, these add up pretty quickly.
right.
They add up pretty quickly, and in estates, especially that are leveraged, when we see this happen, it's unfortunate. We need to get paid for the work that we do, but what you don't want to see at the end of the day is for the estate to get depleted by fees and costs and filing fees and et cetera, when all of this can so easily be avoided.
Yeah.
By a trip to your estate planner and getting that set up in advance.
Yeah. So speaking of that, like, let's say it's a basic trust or a basic estate plan that has one house that's worth $1 million. Rough idea, give me a range of, like, is it 5,000, 10,000, somewhere in between to set that up? Or
depending on the circumstances, I think that you could expect to see attorney's fees in the range of around 3,800 and up for the
wow.
estate planning. And there's a lot of factors that go into that. No two estates are alike. And obviously, the more assets you have, the more things you need to plan for, the more structure you need to put into it, and the more it's going to cost.
Yeah, gotcha. Okay, 3,800 to whatever, versus like 100,000 in litigation and all that stuff sounds far more reasonable. So
yeah, when you compare it against the average probate that we do, ends up running somewhere in the $20,000 in attorney's fees range and up from
yeah.
there. You can imagine with that fee scheme that I mentioned, if you just own a house in Southern California, you're at about $1 million estate in a lot of places, easily in a lot of places in Southern California, especially here in Pasadena, and also in our other area down in Long Beach. That's very, very common for that to happen.
Yeah.
There's one other thing I want to mention with regard to the costs of putting an estate plan together.
Mm-hmm.
And they're far outweighed by what it costs to go through probate, but they can also be far outweighed by putting something together through a non-attorney or through an inexpensive online service. And I say this not to slander the other folks who are trying to help out, but to provide some caution here. For one, in the state of California, it's not legal for a non-attorney to draft a trust for you.
Oh, interesting.
It's considered the unauthorized practice of law. And that's because creating a trust and creating an estate plan involves so many different areas of law that we as practitioners need to be aware of and need to take into consideration while we're putting your documents together, that having a non-attorney do it is simply unwise. And two, in the litigation side of our practice, we see all the time trusts that were clearly created online, and it opens the door for fraud to be done to the settler, because unfortunately we see a lot of elders having these trusts created by an unscrupulous family member or third party who, sets them up online and gets them to create this document without having any legal advice. And then those are the cases that end up in court. And when litigation is concerned, as I'm sure everybody knows, litigation is very, very expensive. You're paying for your attorney's time. And that time adds up very, very rapidly. And it adds up to some pretty big bills.
Yeah, absolutely. Yeah. And I second that. Use a professional for sure, not an online, whoever, you want to know that you're doing the right thing and that your wishes, we just went through this with my fiance's grandparents, like they have specific wishes. Well, if you want to get those met, using a professional is so, so important, so yeah, that's great. Well, I have a sort of a tax question for you. Let's say me and my sister, right? I have an older sister. She's a couple years older than me. And we'll go back to that $1 million house. If I buy my sister out of that house, right? Let's say, I give her 150,000 because there's only a 300,000 delta there. What happens to the property tax? Like, does it change drastically, or like, is there a new basis for that? What happens there?
That's a really great question, Jeromy, and one that we get a lot. And unfortunately, one that we see when people try to go it on their own, they make some mistakes, which will cost them thousands of dollars a year annually. So really? I'm sure you might be aware now that California has passed what's called Proposition 19. And what that means is that when a parent passes real estate to their child, the only exemption that they can get from that, barring some other planning and advance work to be done, is if it's the parent's primary residence and becomes the child's primary residence. Well, what happens when you have an estate that's divided between two or more siblings, or two or more people in general, is that if the estate can't distribute the property to one child and an equal amount of money to another child, and the solution to that is for one child to buy another out, the county will reassess 50% of the property. Or if it's to be divided between three siblings, they'll reassess 66.66% of the property. And unfortunately, we see this all the time too. There is a very easy solution to avoid this while the property is going through the probate administration and even in trust administration, that can make it so that equal distributions are made to all siblings. And thus the sibling who ends up with the real property can go live in the house that their parents lived in without having any of the property tax reassessed. Oh, wow. This again is just yet another reason why you want to pay those fees and hire a knowledgeable attorney to handle this for you, because the consequence of not doing that is that when that property gets reassessed, generally speaking, you're looking at thousands of dollars per year, basically for life, that you have to pay extra that you wouldn't have had to pay with proper planning.
Right. And I feel like, having been in the financial planning industry and now real estate, I feel like everybody is after, especially nowadays, right? Taxes are expensive, inflation's up, property, values are up, the cost of everything is up, and everybody wants to save money. And sometimes saving money means spending a little bit extra money on the right person, the right professional, the right individual to protect you from all these things, and make sure that you're going in the right direction versus, I'm not going to pay those fees, but then you end up paying way more than you ever would have over the course of, the rest of your life, because you didn't plan properly. So that's amazing information. I wasn't aware that they did a reassessment like that. So that's great. That's great. Do you have any questions on the real estate side for?
I do. So, one of the things that we encounter a lot is we have clients come in who are probating their parents' estate, and they're in a situation, or maybe they're administering a trust, and they're in a situation where the real property that belongs to it is run down, but nevertheless needs to be sold. What do you recommend, Jeromy, when people are faced with that type of situation and maybe the estate is not liquid enough to pay for the renovations and updates that that the property needs?
Yeah, that's an amazing question, and it kind of goes across real estate, but really, I've seen it many times in different probate sales. And one of the things that you can do is, if you are working with the right real estate agent, sometimes they will help you with the costs of staging for one. That on us, like, let's say the house is nice. Right, there's not much to do, so they'll help you with the cost of staging, and then get reimbursed for that in escrow. So when you have the full proceeds of that, they'll get reimbursed. But if let's say it's a house that your parents or grandparents have lived in for 50 years and haven't touched it, and it's a time capsule, right? And the green shag carpet needs to be removed. We work with a couple of different contractors and a couple of different companies that will actually go in and do kind of a light remodel, do the floors, do the paint. We call it putting lipstick on it, just to make it really nice for a sale. And you can get anywhere from 15 to 20 on up % above what you would normally get if it's just, here, we're going to sell it as is. Because if you sell a property as is and it's really rough, what you're going to face is these guys who are doing fix and flips, and they're going to lowball all day and not give you what the property's worth, so they can fix it and then sell it for a lot more, right? So working with the right professionals, they can get you that stuff without you having to come out of pocket, and then it just comes out of the proceeds in escrow, which is really nice. So
wow, that's great. So really, if I'm hearing you correctly, the difference is who gets that equity, who gets that value. Is it the estate, or is it going to be some third party who wants to turn that over and make a quick profit?
Yeah, because if you're putting in, let's say, $20,000, right, you could potentially get an extra 30 out of that. So, like you just said, do you want the 30, or do you want to pass that 30 or 40 or $50,000 on to somebody who's just gonna kind of do a light renovation anyway and put it back on the market? It's not going to be an end user. It's not going to be a family that needs housing. It's not going to be somebody that appreciates the property like your family did. So there's definitely ways to increase that value, increase the overall value of the estate, and without coming out of your pocket. So we can definitely help with that and look into it, and we have lots of resources. So happy to help people and walk people through that anytime. So that's great.
That sounds great. That provides a lot of value to families. I've seen this happen where, it really matters how much comes out of that estate to the family. Maybe the person who passed away was the income earner, or in another scenario, there's, the idea of building generational wealth and stuff gets really hampered when you take the shortcut and just liquidate without looking into alternatives.
Yeah. And I mean, something like that could, you look at it as, hey, this is covering all the attorney's fees and all the legal fees, just by doing something without actually having to put money in. So there's lots of ways to do that. So awesome. Tony, thank you so much for, taking the time out of your day. I know you guys are busy with all of your stuff and all of your probates and estate planning. So I appreciate it.
Thank you, Jeromy. You as well.
All right. We'll talk to you soon.
Okay. Take care.
All right. Bye.